Dear learners, welcome back to your educational channel Learn and Educate. In this video, we would be studying about the provisions of the Income Tax Act 1961. As per Section 2, Clause 42, resident. The definition given as per the Income Tax Act 1961 regarding resident is resident means a person who has been resident in India as per the meaning which has been given in Section 6 of the Income Tax Act 1961, wherein the Section 6 speaks about the residence of the persons being an individual or a partnership firm, a Hindu undivided family, or a limited liability partnership firm, or an association of persons, or a body of individuals, or a company which is registered under the Companies Act of 1956 or 2013 or under previously any other act. And it includes the corporations, the statutory bodies, and the bodies established by the chartered issued by the pre-independent India. Moreover, the definition of persons includes many more, which is inclusive, wherein the residential status of the persons in India is as per the provisions of Section 6, wherein the individuals or the Hindu undivided family would be classified under resident, non resident, and under the definition of resident, the classification of resident, the individual or Hindu undivided family would be classified as a resident and ordinarily resident, and second is resident but not ordinarily resident. And other than individual and HUF, which are firm, limited liability partnership firm, a partnership firm, an association of persons, or body of individuals or company. This would be classified under the two category of resident. That is, two cases, two scenarios, resident and non-resident. The residential status deals with the purpose of applicability of taxes, the incidence of tax on any assessee. It is dependent upon that person's residential status as per the Income Tax Act 1961, wherein the three different types of categories, the classification is of the residential status is resident and ordinarily resident, resident but not resident and ordinarily resident. This is first one. Second one is resident but not ordinarily resident, and third one is non-resident, wherein the residential status classification is dependent upon the stay. It is ascertained the residential status of the person of an assessee under the Income Tax Act will be ascertained, calculated with reference to the each previous years, wherein the person who is resident and ordinary resident ROR in 1 year may become a non-resident in the another year, or a person who is a non-resident in the 1 year would be resident in another year. This can happen, wherein it depends upon their stay in the previous year, which may be 182 days or more, or he that person has been stay in India. Individual has been stay in India in the 4 years immediately preceding the previous year, for wherein that number of calculations, the number is more than 365 days or more, then that person would be resident. It includes the stay in India, the stay in India, the definition of India when come into consideration. Moreover, the categories wherein the residential status of the Indian citizen and the HUF would be calculated, wherein the stay would be with respect to coming into the India, destination in India, departure, arrival would be taken into account, wherein and for the purpose of the persons who are redeemed resident, wherein they are liable to pay tax, resident, only Indian resident can be deemed resident, wherein they the income derived received deemed to be resident in India shall be taxed. Therefore, the resident as the word which respects to the person, with respect to the person as per the Income Tax 1961, will is a resident in India as per the meaning given for that purpose in Section 6 of the Income Tax Act 1961.